Hi there, I'm Jarrett, and welcome to Relitigated, the show where five friends who are absolutely not lawyers attempt to retry a real Supreme Court case. This is episode 3, Wolf v. Colorado. It's also the second part in our three-part series on the development of what's called the Exclusionary Rule. If you missed the first part of the series and prefer to get caught up, feel free to listen to the previous episode before this one if you like. A quick note before we get started, as always. We try our best to represent the facts and decisions in the case as accurately as possible, but we're not lawyers, and nothing in this episode should be taken as legal advice. With that out of the way, let's start the show.
Very diligent, very fast. He was amazing.
Wow. Shout out to him. I hope he's doing well, wherever he is.
So any DoorDash
Eating
users
lots
out
of
there,
snacks.
keep a lookout for this young man. He's a go-getter.
Yeah. What a guy.
Hey, hi there.
Hi.
Hello.
Hello.
Welcome to the Relitigated podcast, y'all. I'm your host, Jarrett. I'm joined by my co-host, Nikki.
Hello.
We also have with us three friends who will be role-playing as our justices. First, we have Associate Justice Adam. Hello, Adam.
I'm just here for the powdered wig.
So much
Sounds
powder.
about right.
Just everywhere.
It's everywhere. It really gets in all the crevices.
Next, we have Associate Justice Chris.
Hello.
And lastly, we have our Chief Justice, Sarah.
Good day to all.
If you're new to the show, here's how this works. Nikki and I have selected a real Supreme Court case, and our justices do not know what case we have selected. Although, to be fair, none of us are lawyers, and I'm pretty sure that if we had told you in advance what the case was, you wouldn't know what it was anyway. So, there's that.
That's true. Oh, we're going to deep cut this week. All right.
Yeah. Zero legal expertise from anybody here, by the
That
way.
really helps with the impartiality of it all. Yes.
Yes.
Yeah.
All right. So, Nikki's going to introduce the case to us, walk us through the facts and the events so that we can all get familiar with the details. And the justices are free to ask factual questions during this time. And we're going to answer those as best as we can. We don't have all of the answers. Turns out we weren't there, but we'll do the best that we can. Next, we'll move into oral arguments where Nikki will role play as the petitioner and I will role play as the respondent. We each get 7 minutes to make our case, during which the justices are free to interrupt us and ask any probing questions that you like during that time period. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. The majority opinion wins. And even if two or more justices agree in principle, you can disagree as to why. Once we've had our fun with our mock hearing, Nikki and I will reveal what the Supreme Court actually decided, and we'll talk about how we feel about the actual results and why this case matters. Sound good to everyone?
Never heard anything better.
Awesome. Cool. I'll turn it over to Nikki, who will introduce this episode's case.
We are discussing the Sarah Court canon. So,
What?
in our previous episode, the
Oh
Sarah
my God.
Court. Yep.
Yeah.
Yeah,
Let's fucking go.
Yeah, the court, it's always named after like the head justice. So this is the Sarah Court. And so in our prior episode, Weeks versus United States, the Sarah Court established the exclusionary rule, meaning that the Fourth Amendment requires that evidence obtained from illegal searches and seizures are not allowed to be used as evidence in federal criminal cases. And that's cool because it also goes along with the real life SCOTUS precedents. As a side note, the Sarah Court canon also established the porque no los dos doctrine, which is that evidence should be excluded from trial and also the officer acting illegally should face punishment.
Yeah.
So
Get everybody.
yeah.
Guys, we're establishing our own body of jurisprudence.
Yes.
Can I say just how much I love that word? Because it contains two of my favorite words, jurist, which is what we are, and prudence, which is what we are striving to be.
And yet failing.
Wow.
No, I was
Incredible.
wondering how long it was going to take for somebody to say jurisprudence correctly.
Nikki,
Not long.
Sorry. Continue.
So so that's the we're calling this canon because that's a fun internet word to use. Okay,
I get it.
So now we come to the case of Wolf v. Colorado. And this is information obtained courtesy of a write-up from Professor Joel Samaha at the University of Minnesota. But in any case, the facts are as follows. The chief investigator with the Denver County District Attorney's Office got an anonymous phone call stating that a woman in a local hotel was ill from an illegal abortion. Investigators from the office went to the hotel, located the woman, and sent her to the hospital. When this woman was questioned by the investigators, she revealed that she had indeed had an abortion. She also identified the two doctors involved, one who performed the procedure and the other who had examined her before and after. The doctors were arrested on a charge of conspiracy to perform a criminal abortion. One of the doctors, the one who had examined her, was J.W. He was a physician who specialized in obstetrics and women's health care. When he was arrested, officials from the DA's office searched his office, and during the search, they seized 2 books. These books contained patient names and the dates that he had seen them. There was no warrant for his arrest or for the search. The chief investigator talked to the press, telling them that the investigation was proceeding and that it was following leads from records seized in the raids. His female patients were contacted and questioned, and 6 reported that J.W. had helped them get abortions. They identified 2 other persons involved, and those were C.F. and B.F., and those 2 persons were also arrested and charged with conspiracy to perform illegal abortions. J.W., the other doctor involved, A.M., C.F., and B.F. had trials by juries. The books, the day books, and the patient testimony were the evidence against them. J.W.'s attorney objected strongly to the introduction of the evidence. He argued that the officials did not have the right to search the office without a warrant, access information that is privileged under the law, and then contact patients. He further asserted that the seizure violated the Constitution. The court overruled the objection and allowed the books and the patient's testimony to be admitted as evidence. J.W. was convicted at both of his trials. For his first conviction, he was sentenced to between 1 year and 18 months in prison. And for his second, he was sentenced 15 months to 5 years. The other co-defendants were also convicted and sentenced to prison. J.W. appealed his convictions to the Colorado Supreme Court, with his attorney again arguing that the search had been illegal and the evidence it yielded should have been excluded at trial. The Colorado Supreme Court had previously ruled that evidence from searches and seizures in violation of the Colorado Constitution was still admissible in state courts. What needs to be considered is whether it is, quote, relevant, material, and competent, not whether it was obtained illegally. Therefore, the Colorado Supreme Court held that even if the search of J.W.'s office had been illegal, its evidence was still admissible under Colorado law. And they noted that the law should not be overturned just so J.W. could escape the consequences of his actions. And so with that logic, the Colorado Supreme Court upheld the convictions. He then appealed to the Supreme Court. And so now the question before the Sarah Court is, does the 14th Amendment requirement of due process apply to state criminal trials?
Wow.
I have a lot of other questions.
Colorado?
That's not that one.
That was not a question. That was just, yeah, I can see how you thought that was. Anyway, continue, please, Chief Justice.
No, that's it. I just
Wow.
let's proceed. Let's see what happens. This one's gonna be fun.
I believe it was Tom Hardy in Mad Max who said, "That's bait." This seems suspiciously cut and dry.
Yeah.
Yeah.
There's got to be some extenuating circumstances I'm not smart enough to figure out right here.
Oh yeah, our lack of legal expertise is going to come bite us in the ass.
Okay, guys, I got a dumb
pretty
question.
hard on this one.
I'm just going to put this out on the table. Colorado is part of the United States, right?
Yeah, pretty sure.
Still?
To my knowledge,
All right.
Hold on, let me check.
it's one of the 50.
Checking.
Oh, don't look at
Enhance.
Wikipedia. It's woke.
Enhance. Yep. Still part of the U.S.
Yeah.
Shit.
They got mountains though, so sometimes
Okay.
people are high.
Yeah, they're higher than the rest of us physically
They look
and
down on us, but
spiritually.
yeah.
Literally, they have the true moral high ground.
Are there any factual questions that you have?
Yeah, about the facts leading us to this point.
Why didn't the cops bother with a warrant?
It's right. So the doctors were arrested. So they got the anonymous tip, right? And the doctors were arrested. But why didn't they get the warrant? Like they just like, oh yeah, you guys did a bad thing, and then just arrested them without.
Yeah, everything about this just seems so hasty.
Right. And they searched the office while they were arrested?
I mean, I'm thinking like HIPAA violations left and right too.
Also
like,
true.
I'm going to guess that wasn't a thing.
Yeah, I mean, this maybe clues us into when this happened. Like,
Also true.
are
Yeah.
we able to just walk into doctors' offices these days and get a list of all their patients and call them up?
I was going to say in a convenient single handwritten book.
Hi, sir. Did this doctor give you a colonoscopy last Thursday? We'd like to ask you some
Yeah.
questions about that.
It's all in there. It's all in my diary. And then you get the
Even-
occasional
even
rogue
bef-
doctor with an eidetic memory who never writes anything down. The cops will never get him.
Even before HIPAA,
Yeah.
right? There was patient doctor confidentiality of some kind. I don't know what it was. I'm just assuming. Maybe that's not true. I don't know. But even before HIPAA,
Really big assumption.
it's a big assumption. But even HIPAA really just protects your data. It's you are the owner of your data, and you decide who gets to see it or not. And yeah, I don't know. It's this is
Okay.
like confession with a priest.
Like roughing a guy up a little
Not
bit.
supposed to
Oh,
be
that kind of
friends.
confession. I thought you meant like at the police station. Okay, I have a question. Do I have a why? Why are the police so zealous about prosecuting an abortion?
Oh, well, I mean,
Like, so okay. Sorry, let me back up a step. They
I
get
will
an
say it's
anonymous tip.
irrelevant. It's irrelevant to the constitutional question, but I guess what I would say is it was against the law to perform one.
Okay, yeah,
Or
thank
it
you.
was,
That's-
it was
Colorado?
performed under circumstances where it just there was something about it that was illegal and it was a violation of state law,
Yes.
allegedly.
Right. Forgive me. I'm not clear from my reading or my research that that abortion was necessarily illegal in Colorado. So I misspoke. More correct to say what the cases all seem to say, it was an illegal abortion, but what made it illegal, I actually am unclear of. Was it just outright outlawed, or was it because it wasn't done in like a secure medical facility? Like, I don't
Yeah, it was
actually
done
know.
in a hotel.
Right.
All right.
I mean, yeah. I mean, that certainly seems not quite on the up and up.
I got to be honest. I understand now why being a judge is so hard. This whole impartiality thing is really difficult. How can you just ignore extenuating circumstances?
it's not all powdered wigs all
It's
the time,
not
Adam.
all
you know?
powdered wigs and fancy Mai Tai lunches. I assume that's what they do.
Mai Tai lunches.
Martini, excuse me.
Today I learned a new stereotype of judges I'd never known about.
Very white.
I was like, do judges drink Mai Tais? I mean,
No,
I'm sure they can.
I think we just learned a thing about Adam.
Oh,
Yeah, I
that
think so. Mai Tais and martinis, they're basically the same thing.
Honestly, one's very fruity.
So,
I'm basing everything I know from Mad Men, which was a documentary, I presume.
Of course.
Filmed in
yeah.
real time.
Lucky
nonfiction.
strike.
So
Uh,
okay, so the cops followed a tip, but my whole point about this, why the cops are so zealous, is like that had to be some tip. That had to be like, if you go to this exact place at this exact time and find this exact suspicious leather-bound book on this doctor's desk, you're gonna find crimes.
Well, the tip was there is a woman who is ill at this hotel.
Interesting.
So they went to the
hotel.
the woman
Right, yes,
who was
yes.
ill, and were like,
Yes.
"Why are you ill?" And she was like, "I had an illegal abortion."
Okay. I followed that trail of evidence very poorly.
So she ended up in the hospital. Yeah, and then once she started like dropping names, then that's when they went after the doctor.
Oh man, see, that feels like enough evidence all in one place to obtain a warrant. So I'm led back to this question of like, what about this made the police feel like they had to circumvent due process?
Quota.
I guess there's really no objective answer to that the court can provide, but I'm just musing.
So we are trying to figure out if the rules of excluding evidence obtained without a warrant, because all of this, once again, I'm seeing a common theme here. People not using warrants for things.
Right.
I guess nothing matters.
This keeps happening.
For federal courts, does that also apply to the Colorado State Court?
State charges, yes.
If the state doesn't really have a law that determines that, because of the 14th Amendment's due process clause. So,
yeah, that's it.
We can argue about it if you like.
I'd love to fight about it.
We've prepared some statements, in fact.
Yeah, I feel like we've collectively stumbled in a confused circle for quite enough time, which is court protocol. So please,
par for the course,
if you would, with your arguments.
Okay,
Nikki, I'm going to put 7 minutes on the clock for you, and you'll be going first as our petitioner.
Yes,
and you can start now.
Okay. So first, let's discuss the Fourth Amendment, which specifically states that people have a right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and shall not be violated unless with a warrant, basically. So under the Weeks case, this court has held that in federal prosecutions, the Fourth Amendment prohibits the use of evidence obtained illegally, and, as established in Weeks, protection against arbitrary intrusion by the police is the core of the Fourth Amendment and is basic to a free society. It should make no difference regarding whether the government is state or federal. All are subject to the Constitution, and this protection is necessary for a free society. I also want to call attention to the Due Process Clause detailed in the 14th Amendment, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." The text of this amendment tells us that due process is necessary and applicable to state criminal cases in addition to federal cases. If a state condones police intrusion, that would run counter to principles fundamental to the founding of this nation. It also communicates that, but for the uniform of the official, a citizen may or may not have basic rights. It is especially important to hold state and local officials to the requirements of the Fourth Amendment because these are the officials that have the most impact on most people's lives. When citizens are in need of assistance or police intervention, they're going to turn to local authorities rather than try to locate a federal officer who may or may not even have jurisdiction. There are way more city, county, and state police officers and investigators than there are federal officers. As a result, the ordinary citizen is much more likely to encounter local officials in their daily lives than they are federal officers seeking to investigate and prosecute larger-scale federal crimes. Local authorities are the face of government action for most people. So if this due process protection is not granted to individuals facing prosecution in state courts, there might as well be no Fourth Amendment or 14th Amendment as far as most citizens are concerned. In JW's case, the evidence was obtained under circumstances that are clearly illegal and untenable in federal courts. his rights have been violated, and because he had no security in his papers and effects from an unlawful search, he was essentially forced to be a witness against himself, which is in violation of the Fifth Amendment. Therefore, the evidence against him should have been excluded, and the court should overturn his conviction. The Bill of Rights was written with the expectation of and the intention of limiting government intrusion, overreach, and misuse of its powers against individuals. We therefore can't just expect the district attorney or police to monitor themselves. Failing to exclude illegally obtained evidence does nothing to prevent the authorities from engaging in illegal practices and violating individuals' rights just to make a case. So it's not enough to just leave it to the violated to like mount legal action or to sue or to go and complain to the police. I'm going to point out that this case has been pending for over 4 years, and JW has essentially served out one sentence and is still in jail or finishing his jail sentence for the other. Even if he is back home, he won't get the time and the loss of liberty back, even with money. So the best redress is prevention of an unjust prosecution by the explicit protection of rights. The best prevention is excluding the evidence with the formal application of the exclusionary rule to state proceedings so that will deter police from acting illegally. Authorities can establish rules for searches within the scope of the Constitution and then train police officers to follow them. But that is really what I would like to make clear to the court. This is not just an issue for federal courts. Given just the impact, the number on local citizenry, this should also apply to state courts. Thank you very much, and I will take questions.
Yeah, I don't have a question at this time. However, I do think that we should consider the porque no los dos clause in this one too. And while also freeing JW and, throwing out all evidence held against him, we also punish the Colorado state court and everybody that works there.
We do balance how fair we are with how bloodthirsty we are. That's true.
We do.
In this court.
So I just want to throw that option out there.
Also not a question.
I'm thinking that might be plausible action here.
I'm going to put a pin in that decision for now. I do have a question.
Mm-hmm.
Let me ask this in idiot for you to answer for an idiot, if you will. Are you essentially saying that the prosecution is arguing in this case that your rights don't apply to you unless they've been violated by an FBI agent or other federal agent?
That is my position.
The local police, the state police, any other interstitial law enforcement body between federal police, none of them are obligated to respect your constitutional rights in any way.
That is my position. Without specific exclusion, as established in the Weeks decision, that is what that's going to be the taking from it.
Interesting. No further questions on my end, Nikki.
Thank you very much.
Yeah, no questions for me either.
The prosecution, yet again, has what the court likes to refer to as a steep climb.
Yeah, good luck, Jarrett.
I'm the respondent. There's no prosecution in an appeal.
But he is representing the prosecutor.
The
state of Colorado.
Sure how much more clear I can make that I am making this up as I go, and I don't know the rules.
The powdered wigs are doing all the work here.
The powdered wig has gone to my head, physically, metaphorically. It's on my head right now. It's making me mad with power.
Like nothing brings me more joy in this world than playing devil's advocate. So,
you are very good at it.
I'm very excited to be once again this episode's heel.
Are you calling the government the devil? Because I think that's what you just insinuated.
It's a phrase in common parlance.
I concur, though.
The court will make it known that they will not take my words literally, but figuratively.
Yes.
If I could please get 7 minutes on the clock to not be listened to during, that would be great.
I'm going to listen to
We
you
will
real
allow
hard
it.
so I can rip you apart.
All right, hang on.
Wait,
I'm pulling up
impartiality.
Okay.
Yeah,
and
I do love the. I don't have a question, but I am going to tell you my opinion right now.
Ooh, judicial slam.
Oh wait, this guy has to go next. All right, forget I said that for now.
jurisprudence.
Chief Justice.
I think the way they do it on the actual court is they just ask a very leading question that shows it's like, so you're totally correct, right?
Man, the real power move is to take a bribe and then never say anything.
Oh yeah, we should get into that for the next episode.
Jesus.
Pay us.
First we had
Sponsor
lotteries.
This episode is not sponsored by anybody, but Adam is sponsored by.
An aggressive
The
hatred of
defense.
late-stage capitalism.
All right, I'm
All right.
I'm ready to do this.
All right, and your clock starts now.
All right, here we go. Miss Chief Justice, and may it please the court. While I appreciate the opportunity to come and be here today to respond to this absurd petition, I'm a little shocked at our choice of venue. You see, my understanding is that this here court is the Supreme Court of the United States, which makes this a federal court, which is fine, but the federal government wasn't involved in this case, like, at all.
Oh
The
my
officers were all local police officers in the state of Colorado. The defendants were tried in a Colorado state court for breaking a Colorado state law. And the last time I checked, the state of Colorado's Supreme Court has, on multiple occasions, ruled that in the state of Colorado, how evidence is obtained is immaterial to whether or not it can be used in court. The most recent time they ruled this way was in this exact case before it came to this court. So you can see my confusion as to why we're even here. But it gets even more confusing because this court itself has sided with the states many times that they get to choose the rules for how their courts operate, as written into law by representatives of the people of those states. Here's just a taste of your own jurisprudence. Hurtado v. California. This very court ruled that it was fine that California didn't require a grand jury indictment to try a defendant, since that's just what California law said. Twining v. State. This very court ruled that the first 8 amendments only tie the hands of the federal government, and the 14th Amendment's due process clause does not, repeat, does not extend the protections of those 8 amendments to tie the hands of state governments. Palco v. Connecticut. This court ruled again that the 14th Amendment's due process clause does not guarantee the protections of the first 8 amendments for citizens from state governments. It only applies to the federal government. Are you noticing a trend here?
Are we
Maybe
allowed to interrupt?
Guys, did we say all
absolutely.
Yeah.
Yeah.
Oh, hey. Hi.
that? I don't remember saying that.
Are you trying to say that the state of Colorado? What? I don't know. Something about the state versus federal government part of this seems a little bit familiar to me.
It's not just about defending slavery anymore. It's also about the bridging the rights of individuals.
Yeah. So, Jared, are you proposing that, like, the state of Colorado, the court could say that we're going to, I don't know, execute the worst juror, for fun as part of our court process? But, like, even the federal courts or the federal law says, hey, like, you can't do that. The Colorado state court's going to be like, oh, yeah, but we want to do that, so we're going to do that. Is that okay?
Like summarily execute a juror? No, that would violate other things that this court has upheld.
Or, a petitioner for the state.
For now.
Whatever. I'm not being specific.
Yeah, we're just talking about the operational rules that judges are governed by and how they make decisions. are a matter for the state. And it's not me saying that. It's all of your previous colleagues in all of these previous cases.
Yeah, I think we did say that, guys. I'm pretty sure you did mention
Justice,
that.
our government is a
but
federalist system. It is a nesting doll of jurisdictions and governments that each have their own rules. From the federal to the state to the local, they have similarities, but they also have differences. For the federal government, the bedrock principles of how it behaves and what protection citizens have from it is the U.S. Constitution. When the federal government gets involved, the U.S. Constitution applies. We saw that recently when this court, I'll argue correctly, stated in the Weeks v. United States decision that at the federal level, this court doesn't like the idea of evidence being entered that was illegally obtained.
Yeah, that's
and
canon.
that's fine.
No, we don't.
Because these are Supreme Courts, are not okay with it.
Yeah, we don't like it.
And that's and that makes sense because these are federal judges ruling on federal procedure in federal courts. That's totally cool. Lost my place.
I kind of understand.
Lost my train of thought.
I understand it. Yeah.
Go ahead, Justice.
Well, I was just saying, I understand, should we, as a Supreme Court, rule over the state court that basically says, hey, your decision was wrong, even though there were no federal agents involved at all.
That's what I'm saying.
Does the Supreme Court hold that power over the state courts, even if nobody involved in the state was a federal agent?
Yep. And multiple times, this court, that's the precedent that's been built up over years. Even in that week's case, the court did not go so far as to violate the sovereignty of the states and demand that they apply extra rules that their own citizens didn't vote for legislators to write into law. Hell, even before the week's decision, in the Adams v. New York case that was mentioned in the arguments by a dapper respondent, officers seized more property than they had a warrant for, and then they used that extra property as evidence. And this court said that it was up to New York whether or not that was okay. And New York was like, it's okay. So the court was like, that it's okay. I believe that there might be a desire here to let a guilty man go free on the assumption that this might provide a deterrence to police officers. But such a policy decision is the work of legislatures, not courts. The states can decide for themselves how they want to implement a system of deterrence and punishment for the officers who fail to follow their rules. They also get to decide what those rules are and how they're going to be followed in the first place. Otherwise, we're going to have to get into the weeds of every state's law. It just doesn't make sense for the federal government to do that. The precedent is clear. The 14th Amendment does not bind the states to the first 8 amendments of the Constitution. Only the federal government is bound by the first 8 amendments and the 14th Amendment in its conduct. As such, it's actually the 10th Amendment, which is the most important one at play. And it's a simple, elegant sentence. Quote, "The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people."
Garrett, you are at time.
I'll put the last 2 paragraphs of my thing up on the website.
Yeah, please. We need captions, cliff notes.
Yes.
Petitioner, respondent, whatever I'm supposed to call you. I have the powdered wig, so it really doesn't matter. I do want to ask, tortured thought experiment, the answer to which will absolutely not determine my judgment in this case. Are you saying that unless a state constitution explicitly provides the right to free speech, that the state authorities, the state police, local police, can detain and execute someone for exercising the wrong religion?
That's what I'm saying.
As long as no feds were involved. As nary an FBI agent or IRS police officer who was involved in this illegal detention and burning at the stake. And therefore, it was on the up and up.
Should a state pass a law the Supreme Court, if it is challenged, it can be challenged to the Supreme Court, and the Supreme Court can decide on a case-by-case basis if it believes that that law is unconstitutional.
Okay, so if the we can burn witches law has not made it onto the Supreme Court's docket in time, local cops are free to have their barbecue. Hypothetically.
That's actually just kind of how the law works, to my understanding,
Shit,
Your
really?
Honor. Unless
Who gave me this wig?
power is always capable of being used. It is only in the challenging of it that it becomes restrained.
Wait, are you telling me that it's all an illusion of safety?
We could be barbecuing witches right now?
We could be barbecuing witches right now, and as long as Johnny Law takes a minute to figure out what's going on, we're on the clear. Whoa.
Damn.
Guys, that's a lot of power for me to have. Okay, I have another question. What is the boundary between state and federal property in this case? Is it strictly a matter of who is enforcing the law? Is that it? It doesn't matter where it happens. It's
Also,
strictly a
whose
matter
law?
of who it is who's enforcing the law. What's that?
Also, whose law?
Yeah, okay,
This
that
was
makes
Colorado law
Yeah.
being managed by Colorado officials in the state of Colorado, and what the petitioner is asking is for this court to become a Colorado state court momentarily.
Mm.
Last I checked, they have their own government.
Gotta be honest. Didn't expect your argument to be so compelling.
Thank you, justices. I rest from lack of time, not lack of things to say.
Yeah, you're way over. I think we're probably ready to discuss or deliberate.
Yeah,
or
get into it.
Jurisprude. I don't know.
Yeah, jurisprudence. That's absolutely the verb.
Jurisprude.
Yeah.
Just the juris part.
Nikki and I return to being clerks.
Wait, you can do that?
You should add a sound effect there where you guys magically return back into clerk form.
Yeah, like a long trombone sting. Like,
yeah, or like the sound of like a magic wand or something.
The court digresses.
Yeah. Okay, guys. How are we feeling? Chris?
I am on the fence about, the interpretation, and also should the Supreme Court tell the state what to do?
Yeah.
Probably not. Probably not.
Also, probably maybe sometimes yes.
But sometimes, in the case of, it really have to look at the what's being argued, like, or what's actually the question, right? And it's more about the evidence, right? Excluding evidence, and as opposed to specifics about the large question at hand, like the illegal abortions and things like that. It's more focusing in on the evidence and the freedom of this man, who has been, in prison or jail for, was it 15 months?
That's a long time.
By the time, or did you say 4 years? How long has this been going? Like,
let me just double check to make sure I'm.
That feels like some violation of some due process, but
it's
again,
right.
Unclear.
Yeah.
But is it the job of the Supreme Court to rule that is bad versus the state court to say, "Oh yeah, we messed up"?
So, how much time are you looking for?
Is it the time that JW has been in jail by the time the question came before the court?
So, I thought I had it.
I thought you mentioned
4 years.
Yeah, so
it's what you mentioned in the argument.
Yeah, so he was tried. Okay, so I have the year that he was tried, and it was 4 years after that the case was argued in front of the Supreme Court.
So this has been going on for quite a long time. And so the state courts, after 4 years of hearing various cases, or hearing the case, and they still have found them guilty, then is it the Supreme Court's place to come in and rule on the state's authority? I don't know.
Man, you're really nailing this whole impartiality thing. I'm very impressed. Very good.
Yeah, right down the middle, dude.
Right down
Honestly.
the middle. That is some King Solomon biz.
Chris is our swing justice.
He's very good. He's the only one who knows how to do his job.
He's my target in every episode.
Yeah.
Your swing voter, as it were.
Yeah. Just riding that line the whole time.
Yeah, I'm usually trying to talk to Sarah.
Yeah, I hear you, Nikki, loud and clear, speaking right to my soul.
We've got Chief Justice Sarah. We've got Swing Justice Chris. We've got Wild Card Adam.
I don't respect the law at all. I don't know who put me here.
I mean, okay, so it just kind of feels like to me, like I'm just hung up on the idea. Like, okay, yes, obviously, we don't want the federal. Actually, no, I'm going to scrap what I was about to say. Like, there's a reason why we have a constitution and why we have amendments. You know what I mean? Like, the states aren't just allowed to do willy-nilly whatever they please. And, you know, I guess they can try to get away from it.
You didn't read the fine print. In Colorado, cops can just break into your house anytime and steal your shit.
Yeah. I mean, I don't know. I feel like the fact, I don't know. I feel like okay, let me back up here. I'm going to go back again to the fact that all of this evidence was taken without a warrant. We just talked about this. Okay. That's like a big no-no.
It's a big problem.
Yeah, it's a big problem. And again, per porque no los dos, I do think that everybody should be punished for that. But I feel like because all the evidence was taken without a warrant, like even though it happened under the jurisdiction of the Colorado state courts or whatever, like is Colorado allowed to just be like, oh yeah, no one needs warrants for anything anymore. This evidence is good to go, and then just like throw people in jail? Like, no, that feels very not due processy, in my opinion.
Right. Let me choose a less extreme example. Right. Like if Colorado decided they could just like quarter their National Guardsmen in your house. Right. Like everyone thinks about the Third Amendment, but that would upset people. But according to this doctrine, like they could kind of do that unless I'm missing something substantial here, which is extremely possible.
I don't know. I mean, my education on the Constitution is it just extends to what I studied in high school and a little bit in college. So
I'm shocked that my brain encyclopedia recalled the Third Amendment here. That's great. I'm doing
actually, that was impressive. Wow. That would have been extreme recall for me.
In times of peace?
We haven't had to worry about the whole quartering soldiers thing in a minute.
Yeah, I don't know.
Which really speaks to our quality of life.
Yeah, good for us, guys.
Nice. Well.
All right. You know what? Even-handed Justice Chris.
Even-handed?
Yeah. Are you not Justice Chris, the even-handed?
He's our swing justice. Swing Justice Chris.
More of a pendulum justice. Yeah, I don't. Yeah, I do. I feel, yes, the 14th Amendment and the question of this. That's the other piece that I'm feeling is that JW has been in jail for 4 years, and
that's harsh. That feels cruel and unusual.
Right. Well, it's a deprivation, right, of his or hers, JW, the doctor's life. So I can see it. Right, I can see the issue and the lack of due process that evidence used against him in court. I can see that. But yeah, the fact that the Supreme Court is here telling the state courts like, "Hey, why aren't you looking at the Constitution?" Right, and I think that's the issue that I have is the states should be using the Constitution as when they are making their rulings as hey, I'm looking at this person who committed these crimes, for which we have convicted this person and gathered evidence illegally. So not great, but very sus.
That's a really interesting question, actually, that is probably best saved for a separate episode. But in the absence of specific legislation in a state, like around whatever topic, and in 2024 in the future, like probably likely to happen at some point in the future, right? Where there's like something important and pivotal that like the state law just hasn't had a chance to catch up and talk about and think about.
That's actually,
does not the court have an obligation to use some sort of established hierarchical framework for guiding what's right? And like, is that not the Constitution? Is that not like
right?
the
I
whole
thought that's
point
why
of that
we had a
document?
constitution. Like,
Right,
I thought
that's
that
kind
was
of why
the
it's
point.
there.
That's why it's there.
It's the
Like, if we just let
cascading
this-
style sheet of legislative guidance.
If we let the state courts just get away with murder, even though the Constitution says, hey, don't get away with murder in your courts, then what's the point of having the Constitution?
Also, should not Colorado have like a little tiny constitution that's kind of like the big one? I feel like that's important. They should really codify the whole freedom of speech thing.
Well, no, if they had that, then that would go against the 14th Amendment technically, because they're not supposed to make or enforce any laws which abridges the privileges or immunities of the citizens.
Whoa.
So it kind of goes against the...
That was
I
very
clearly don't
lawyer
understand how
review, Chris.
anything works. Yeah, okay. Thank you, King Solomon.
That was really good. That was a level of expertise that has
that I do not have.
that has rarely been seen on this show quite yet. So,
well, I am still torn.
Yeah.
But I feel a little bit stronger about the fact that the Supreme Court should not tell the freaking states what to do. I feel strongly about that, right? And the states should be given some level of autonomy when it comes to issues within the state. But when it comes to kind of the bigger things where, we have the Constitution, that is technically national, federal level. Hey, we should be protecting citizens. But whose job is that, right? Is it the Supreme Court's job? I don't know.
If I know Jarrett and Nikki, and I've known them for a minute, they're trying to teach us a lesson. I hate that. And I think that the lesson is sometimes we just have to completely dispel our personal feelings about what's right and wrong and purely examine the legality of the situation, which, again, to be clear, I'm finding very troubling and difficult.
Yes.
But that's what we're here to do. That's why they gave us the wigs. And I think you're right.
Yeah.
Well, my wig is telling me that you're both wrong and Jarrett's wrong.
Yeah,
I think I'm going to go with Nikki. Yeah, I think I'm going to go with Nikki on this one. I just can't seem to shake the feeling that the Constitution is there for a reason. And again, hey guys, I'm not a lawyer, but I feel like the way that this evidence was obtained to throw JW in jail for this amount of time, it just feels icky. Again, no warrant. Massive HIPAA violations. Not that has anything to do with this, but it's part of it in my brain.
Absolutely does.
I just feel like the 14th Amendment is there for a reason, and there's a due process that the states should follow when it comes to trying and convicting people, because that's a big deal and can result in the loss of their liberty and or their literal life. So yeah, I'm gonna have to go with Nikki on this one. I am just not convinced of the other argument. I get that the states should have their ability to do as they please as well, but when it comes to throwing people in jail willy-nilly, the Constitution is there for a reason. So that's my story, and I'm sticking to it.
Wow. Love it.
I propose a new 28th Amendment. HIPAA. just HIPAA. Just
HIPAA in general.
Yeah, just HIPAA. I'm just shorthand. I'm just lazy today. I propose a new 30th Amendment that the Bill of Rights be enforced at the state level, but in a descending order of importance from the First Amendment backwards. So by the time you get into the 20th Amendments, nobody cares anymore. But I feel like the right to bear arms, the right to free speech, those are kind of supreme. Those are like the really important ones. The whole soldiers quartered in your house will ignore that one. The Fourth Amendment, very important. I kind of feel like the state should have to respect that no matter what. So we'll have to let this one slide. I'm going to be a wild card, and I'm going to go with the whole states' rights thing on this one, unfortunately, against my better judgment. But we can make new amendments, and I propose we do so. We got to patch this hole, people.
Wait, can
we
make?
Do we have that
not
power?
We,
like us? Oh,
the royal we.
Congress.
The wig
the
might
collective.
be
Stand to you.
Yeah.
The rules are in the Constitution.
Yes.
We should probably read that.
You should probably read that at some point.
I think it's better
not a
if we
long
don't.
read.
That's okay.
Hey, I knew the Third Amendment. I just trail off after the 14th or so.
Yeah. Okay. Are we all settled in our decisions, my fellow court members?
I don't think we heard from the swing justice.
Oh yes, Chris.
In terms of my final ruling, right? And I want to go back to the original question, right? And the question before us is that if our federal rules apply to the state, if the state doesn't have any law and no federal agent was involved in the criminal proceedings, I have to, I think it's up to the state to decide. I think it's within their power. I don't think the Supreme Court should be making laws, based on, evidence and things like that. I think the Supreme Court should not be in the business of telling the state what to do unless, there actually was something that, and that's why laws that we make are so important. Right. And this is kind of echoing that. It's the laws that are made to protect individuals in these certain situations at the federal level are so important. But also like local elections, right? That's also super important.
I'm sorry, right? Fellow Justice. You trailed off a little bit there. You said, unless they ... unless they violate someone's rights as defined by the ... Constitution. I'm still arguing myself in circles. I don't know what is right.
Yes.
So, damn your even-handedness. You brought me all the way around.
Yeah. You're essentially telling everybody, Chris, to go vote.
Yes,
if nothing else.
That is correct.
I stand for go vote.
That's just good advice.
Yeah.
That's just. But I don't think the Supreme Court should be telling the state court, hey, you guys are bad.
It really does.
Unless they're like,
you guys are big and bad.
Yeah.
Colorado State Court.
So bad, Supreme Court of Colorado.
Yeah.
Let me see if I can summarize here. So Sarah's siding with the petitioner, and the opinion is when we said in Weeks that you couldn't use evidence that was obtained without a warrant, we meant everywhere.
Yep. I'm not playing around.
Hard line.
Be fair, people. Be fair.
And so let's overturn the precedent of the previous cases and just make this the rule of the land, the law of the land.
Okay, well, when you say it like that,
Adam his opinion is siding with the respondent reluctantly, but saying that like this is an issue that could be solved through legislative means, not the court solving it is a little heavy-handed. That was my read of what you were kind of saying.
As much as I want to swing this giant court-shaped hammer and solve this issue, it is best solved by the legislation.
And Chris is siding with the respondent, saying that the 10th Amendment really is the trump card in this one for him. That the federal government is bound by the Constitution, and the states have their own constitution and their own laws, and the jurisdiction, the laws that apply to that jurisdiction closest win.
I do believe you have summarized our views arguably better than we did.
Oh, way better than we did. Good job, clerk.
By a lot.
That's just my job.
Very good. Very good.
So a 2-1 ruling in favor of the respondent.
Wild card.
Wow.
I'm going to be honest, Nikki, that was not the outcome I was expecting.
It wasn't either. I'm very surprised.
Fellow court members, I'm not angry. I'm just disappointed.
Yeah,
I'm also disappointed.
I absolutely am all for, if you want to come up with flowery ways to dissent, that is like very common.
Oh yeah.
In Supreme Court dissents is like, this incredibly flowery language or these very targeted sort of like jabs or whatnot.
Oh
yeah,
shit.
it's like this is like one of very few professions of like where somebody can basically just write an angry email and that's just like included and
can
like
read it out to the
everybody's-
class.
Yeah, and then everybody's just like, oh, these amazing justices who've whatever.
When I air my grievances at work, they're all like, "That's unprofessional," and "You're on a performance improvement plan."
I feel like the Supreme Court like is the living embodiment of the Curb Your Enthusiasm meme, where it's like, "Fuck you, I'll see you tomorrow."
Yeah.
Yes.
Can you imagine how much the real Supreme Court justices hate each other? Some of them, not all of them.
Well-
I'm sure there's cliques, but yeah,
There's definitely
man.
Yeah,
Thanks.
imagine having to go to work every day with your like to hang out with your mortal enemy, like a
Imagine all
literal
of your
mortal
coworkers had
enemy.
lifetime appointments, and you did too,
And your job is to talk politics and religion.
and disagree with each other.
Oh my god!
Oh,
That shit
that's
is
hellish.
for life.
Yeah.
Forever.
For life.
Like this is your
I
life
don't-
now. Why would you want this job?
Yeah.
The wigs are
Cyrus
very
Thomas
cozy.
has said it doesn't pay well.
I was just about to ask, how much are these people getting paid?
Not
Do they get paid?
You guys getting paid?
Yeah, shit.
Well, Adam's got a
Adam's
sponsor.
Adam's
Adam
sponsored.
get paid.
so,
Yeah.
Yeah,
of course,
you
the
guys
lottery.
see my
Yes.
NASCAR jumpsuit. I'm running out of space for advertiser patches, but
I mean,
we'll
he's
do.
the
I'm
only
gonna
one
add
of us with that powdered wig at this
Yeah.
point, so he's getting it from somewhere.
Hi,
I'm gonna add a
I'm
cape.
Adam, and I would like to talk to you today about Jefferson's powdered wigs.
No. This week's sponsor is BetterHelp.
Jeez.
Can we get sued for saying that?
we might have to bleep that out.
Yeah.
You know.
That might actually be a pretty good gag.
Yeah, well,
Sorry.
I actually think it's
Help
funnier
myself.
if we bleep it.
Yeah.
Leave people
Yeah, I'm gonna add a
guessing.
quote
yeah.
to the ensemble, so I got more room for advertiser logos. I'm gonna get
nobody will ever know what he has said.
yeah, let's cut this whole segment.
Before we do any more damage, maybe we should see what actually happened in this case.
I am
Yes.
desperately
I am very
curious to know
curious.
what year this happened,
Begging
and this
you
is
to
the
Yes.
prove
part
me right.
where you horrify me by telling me it was 2017.
Oh God.
Well, yeah.
All right, so you take it away, Jared.
It was not. It was, what was it, the 40s, I think?
It was I had
49?
it pulled it. No, it was
Oh.
48.
48. I was close. 1948.
Wow.
Yeah, it was I have the dates.
World War II.
It was
That's over.
it was argued in October 1948. Oh, it was decided in June of 1949.
Okay, there it is. All right.
Yeah.
And the other case that we did, Weeks v. United States, that was 1914. So that's why we were able to use it as precedent.
Mm.
Wow. Very fancy planning there.
Wait, we're ruling out reverse precedent. Just to
Yeah.
be clear, that's good. That's going to keep things more easy to follow. 1949, interesting. It's so funny that, like, I really just can't get over the fact that the police were so zealous to enforce an illegal abortion. Like, now that we've made our decision, can you guys provide any additional context, like why this was such a priority for the cops?
There's
No,
like
it's
no
not,
information.
It's not relevant. Yeah.
Yeah.
I mean, sure, it's not relevant, but I'm interested on a human interest level.
Well, I guess what I should say is because it's not relevant,
Yeah, it's not
no one
recorded,
bothered
yeah,
to write
it's
it down.
recorded. Of
Yeah,
course,
like
of course.
basically because a professor at I think it was the University of Minnesota, like, and this is a guy with a JD and a PhD, like he nerded out over it. That's why we were able to give all of this background information. Otherwise, it was
Interesting.
just like anyway. So JW was like convicted, and there was like
Yeah, because I suppose that is the record keeping style of the court. You know,
Yeah,
at that
it's
time,
very
kind of
like
forever. It's like
yeah.
here's what happened, and that's it. You get no salacious details because that would defeat the whole purpose of this solemn institution.
That's true.
Yeah,
I will say, just from our doing research, some of the more recent cases, you will find more information. Well, first of all, it's just, if it's within the last 30 years, you're going to find information about it in newspapers, online, and things like that. But also I've noticed that it seems like the Supreme Court started writing in sort of narrative story a little bit into some of the opinions. So there's a little bit more of that too.
Or more recently.
No, like more recently.
More recently, yeah.
Yeah.
I mean, right.
I mean, again, not a lawyer. I could be wrong. I'm just saying
there's some
anecdotally from sort of what I've been
I
reading.
think it's kind of hit or I mean, the older cases, it's hit or miss. Either there's like no information, or it's like here's the whole story. Because like with Weeks, remember, like it detailed like all the stuff that the police took and all the money and
Oh, yeah.
I'm going to go out on a wild limb and propose a conspiracy theory, which we may or may not decide is Sarah Court canon. In the last 50 years, Supreme Court justices have had to kind of audition in the public eye, so to speak, right? And they get like publicly televised congressional hearings to get them approved. And like, especially in the last 10 years, it's become a whole circus. Every single time Trump appointed somebody in their whole confirmation hearing was just a big spectacle. So like it kind of naturally selects for outrageous personalities in a way, like in the same way that like, Nixon would never get nominated as a major party candidate now, with his weird untelegenic personality. Maybe I'm wrong there.
Yeah, counterpoint. Have you ever actually watched one of those confirmation hearings? They want the most boring milquetoast performance you can get.
Milquetoast.
Oh, granted, that's part of the audition, but it's the natural, I think, public attention on those decisions and the ramifications that they clearly have, has made them into something of a media spectacle. And I think that just naturally self-selects for outrageous personalities that do well on television. In other words, a Republican president or Democrat president would never nominate someone that they didn't think could make it through a very public hearing, right? They may be the most accomplished jurist in the world with the most thoughtful opinions, but if they can't sit through a televised hearing and not melt, they'll never get nominated in this day and age. Whereas, 70 years ago, you could get away with nominating someone who was frankly off-putting or weird, and they could get through the confirmation process. And average American reading the newspaper to learn about the whole proceeding would never know the difference.
Do Americans read newspapers anymore?
That's what I was about to ask. But I get your point.
I just read the push notifications when it comes to.
I don't know, whatever kids read.
Yeah.
Yes.
That headline is like,
Let me get through this ruling, and then we can wax philosophic about the.
This is just a really interesting one.
Yeah.
Order in my court.
So this was a 6-3 decision. The actual Supreme Court was also torn on this one, the exact same ratio, in fact. And the court held that while the exclusionary rule does apply to federal cases, the 14th Amendment does not require this in criminal trials in state cases.
I'm going to flip my desk.
I'd like to see that.
This was in part because the exclusion of evidence was not explicitly stated in the Fourth Amendment, and the exclusionary rule was based off of the Supreme Court's interpretation. The exclusionary rule is not a necessary ingredient to the Fourth Amendment protections. They reviewed the practices of each state and found that states have wide variance in whether they adopt the rule or they don't. I think they literally did a case study state by state.
Yeah,
I don't remember the numbers exactly. If it was
I was
30
wondering
states.
this exact thing. I was wondering if they took that into account.
Yes.
What is the overall level of compliance across all the states?
And they looked at it and they said, the states, there is no obvious direct answer here, and so the best answer, I think, is to just sort of turn it back over to the states and let them decide. Court. Well, hold on. That was my interpretation of what I just read. I should say that's.
Yeah, because again, you're not a
well.
lawyer.
Not
make that clear again.
The court found that there were other methods to avoid unreasonable searches that do not fall below the due process requirements. So there are civil remedies. The internal disciplining of police, public opinion and pressure can encourage police to act appropriately. So it wasn't necessary for the court to sort of dictate a remedy if the localities could come up with their own remedy for the situation. So therefore, illegally obtained evidence did not necessarily mean that it had to be excluded in all cases. It did mean that it had to be excluded in federal cases. That was the decision in Weeks, but not in the state cases. I believe this was written by Frankfurter.
I think so.
Wrote the majority opinion. There were multiple dissents. This gets a little confusing because of the 3 justices that dissented, it was one of them wrote a dissent and another one joined it. And the one who joined the first guy wrote another dissent and the first guy joined the second guy's dissent. So this gets a little weird.
Oh, so they were a team on this one. I
Yes.
respect that.
I'm super mad about this.
Wait, what? Do they each like their own stories?
They like they like the other person. It's like, I'm gonna write a dissent, and the other one was like, that's a great dissent, but I'm also gonna write a dissent. And the first guy was like, well, yours is good too.
It's like endorsing each other on LinkedIn, like endorsing your friend on LinkedIn.
Yeah, they're like trying to walk away, but then one person keeps turning around and being like, and another thing, and then the other person's like, yeah.
Dissent 2, Dissent Harder, and Dissent 3 to Dissent 4 Furious.
Dissent Mercenary.
Very jurisprudent of them.
Dissent 5, the remix.
So there's a couple of quotes here that Nikki pulled out that I'm going to read off from you. So the first dissent was from Justice Murphy, and Rutledge joined in this dissent. So here's a couple of quotes from his dissent. It is difficult for me to understand how the court can go this far and yet be unwilling to make the step which can give some meaning to the pronouncement it utters. This is an area in which judicial action has positive effect upon the breach of law, and that, without judicial action, there are simply no effective sanctions presently available.
Oh, so true.
I cannot believe that we should decide due process questions by simply taking a poll of the rules in various jurisdictions.
Yeah, actually, it does when you put it that way.
I wouldn't have even considered a poll. Like, I kind of agree with that piece of that dissent, because I'm like, who cares? Like, you're the Supreme Court. Whatever all the other states are doing, who cares about the other states?
Not
That's
the
like
Supreme Court of Colorado.
So, like, what are you guys doing?
Actually, though, sometimes they do. They look. That's how they look at what the states are doing, and then sometimes that gets used to be like, well, everybody hates Jeff, therefore, like, Jeff sucks.
Yeah.
Yeah,
Like,
Jeff.
Outside the box.
Screw that
idea.
guy.
Yeah.
What's Mexico doing?
I have heard. So I have heard that in the context of when they're making like new laws, right? Like they'll, not in the court judicial system, but in the legislation, like folks will look and say, okay, well, like one state, say like Massachusetts, they'll make a law, and then Rhode Island will be like, that's a cool law, and then they'll make the law, and then if like enough states make the same law, then the federal at the federal level, they'll be like, maybe we should make this a federal law. And like, so I understand that's a common thing. I don't have any specific examples, but I've heard that before.
Yeah, it's like you want to do what your friends are doing,
right?
You don't want to be left out.
Well, that's the whole deal. Like, the states are like the laboratory of democracy or whatever. Got another quote for you here. Today's decision will do inestimable harm to the cause of fair police methods in our cities and states. Even more important, perhaps, it must have tragic effect upon public respect for our judiciary, for the court now allows what is indeed shabby business, lawlessness by officers of the law.
Shabby business is such a great turn of phrase. Fantastic. If we take nothing away from this case, can it not be shabby business?
It's just messy,
It's just a messy affair.
It's like a good band name.
Yeah.
Shabby business.
That's definitely a ska band in the 60s or whatever.
Nikki, you wanna take Rutledge's dissent that Murphy joined?
Oh yeah. So yeah, what Jared just read off was Murphy's dissent, and Rutledge was like in the back hyping him up, like, yeah. So then Rutledge also wrote in with Murphy in the back, and he says, quote, "But the version of the Fourth Amendment today held applicable to the states hardly rises to the dignity of a form of words. At best, it is a pale and frayed carbon copy of the original, bearing little resemblance to the amendment, the fulfillment of whose command I had heretofore thought to be an indispensable need for a democratic society." And he also says, "Compliance with the Bill of Rights betokens more than lip service." And I was like, oh, today I learned in the 40s people were saying lip service with just the same stank that we say it now.
The same vitriol.
I feel like that term was invented like 4 weeks before this decision was written.
I know, right?
It's like hot slang, yeah.
They pulled it in just for this.
Right? It's just to be contemporary. Oh, man. This is... You know what? If nothing else, all these justices, they really got away with words. They're very good writers.
Oh, yeah.
I suppose you don't get through law school without, learning how to write.
And
actually,
words.
hold on, wait a second. Critical question: can just anyone be a Supreme Court justice?
I mean, it seems to be working out for
I
us
think
pretty
so.
fine.
Yeah.
No. Like IRL.
Got a
Like
powder
There is no provision in the Constitution. Like there is no concept of like the bar in the U.S. Constitution.
So there was absolutely nothing
But you're-
stopping Trump from nominating like Rush Limbaugh to the Supreme Court.
That is correct.
I mean, well, except for he's being
Except
dead,
his lack of creativity.
Oh.
Yes.
Yeah.
God, saved by the skin of our teeth.
I'm trying to find some quotes from Frankfurter's decision. It's not as scathing, but he definitely he really does sort of kind of drive it home. Let's see. He says, unlike the specific requirements and restrictions placed by the Bill of Rights upon the administration of criminal justice by federal authority, the 14th Amendment did not subject criminal justice in the states to specific limitations. The notion that the due process of law guaranteed by the 14th Amendment is shorthand for the first 8 amendments of the Constitution and thereby incorporates them has been rejected by this court again and again after impressive considerations. For example, in Hurtado v. California, in Twining v. New Jersey, in Brown v. Mississippi, in Palco v. Connecticut. Only the other day, the court reaffirmed this rejection after thorough re-examination of the scope and function of the Due Process Clause of the 14th Amendment in Adamson v. California. The issue is closed, period.
Wow. Really dropped the mic there.
Yeah, that really was. Yeah, that was the equivalent of a mic drop.
As for the so what? Why did we select this? Obviously, for listeners who've listened to the previous episode, really interesting follow-up on what I think many probably would have assumed. He was like, oh, Weeks v. United States. You can't use evidence that you obtained illegally against people. You violated their Fourth Amendment right by taking their stuff without a warrant, which is bad. But then when you used it against them in a court of law, essentially what you did was made them testify against themselves. And that's where the Fifth Amendment comes in. And the reality is yeah. But when they said that, none of us realized that they were actually just talking about the feds. Which what?
Huh?
And in their state-by-state survey, it looks like, let's see, after the Weeks decision, 47 states made some sort of decision, but it looks like only 20 states were the ones who were like, oh yeah, and also Weeks applies in this state. And so I guess the others were just like, no. Oh wait, here we go. As of 31 states reject the Weeks doctrine. 16 states are in agreement with it.
That's the other thing is it's not even that the states didn't have a rule. It's specifically those states' courts said, this is our rule. Yes, you can use it. The stunned silence.
That's the sound of jurisprudence.
Yeah.
Yeah, the weight of these powdered wigs
on
our shoulders is
upon our extremely big brains and large craniums.
really, really heavy.
It's a lot.
I'm feeling not motivated to go to law school to pursue a career in this.
We don't even get paid for this, it turns out.
No. Well, okay, speak for yourself. Well, actually,
that's right.
I guess you're speaking for us because
we're not supposed to talk about
paid for this, apparently.
Oh, that seems like the Sarah court's been kind of tracking pretty closely with SCOTUS on these issues.
That is interesting. It's interesting.
It's almost like we're extremely wise and jurisprudent. Yeah, I'm going to stop saying that word. Guys, can we do an easy case? Is there any cases about Pokemon or Mario 64?
Well, if there is,
At
you
the
can bet that the
Supreme
court
Court?
sucked the fun right out of it.
I know, right?
Is there a case about like a tomato versus like a shark from like 1910 or something? Like
Old Farmer Joe versus a whole bunch of raccoons.
Yeah, like a bucket of eels versus Virginia or something. Like
that seems very specific.
Virginia lost.
Yeah.
The eels too much. Couldn't
the eels
take it.
persist.
The
Yeah.
eels persisted.
Do you guys know that we still don't know where eels like come from?
Somewhere in the Sargasso Sea.
Wait, what?
Yeah, no. Hey, go if anybody's looking for a YouTube rabbit hole this evening.
Right. When you're done with this podcast, Sarah has
look up where the eels come from.
Yeah, Sarah's an ardent supporter of abiogenesis. The eels just spontaneously generate from kelp somewhere in the ocean.
You know, scientists don't really have a better answer than that, so it could be true. Look it up.
Could be.
And also sponsor us.
Next episode, we'll bring a scientist on to answer the question: eels, what's up?
What's up with those guys?
Okay, I think we've taxed the brains of our justices enough for one day. We have this has been a fun little two-parter between Week now and Wolf v. Colorado. We've learned some things.
Indeed.
I'll be honest, because we don't know what was like actually argued in front of the justices for cases within like the last 40 years or 50 years. They actually do have the audio available and transcripts. You can actually listen to the arguments for these older cases. Nikki and I are, well, either way, we would make up our own arguments, targeted at you guys, but we would be guided by the actual arguments that were argued. In this one, like, I took a stab in the dark at the 10th Amendment being relevant. It still counts. That's cool.
And you convinced them.
I don't feel good.
I don't feel good about this.
No, but you earned your lawyer wings today.
That's true.
Oh, maybe someday I'll get a wig.
Ooh.
Yeah, you just got to grease the right palms. You got to have a successful confirmation campaign. You got to go on TV and the senators grill you, and then you get your wig.
Sarah is not hiring.
Not how that works.
Firing.
I don't think that's how it works.
Whatever packing the court is, we've done the opposite of that.
Yeah. We've
decimated the court.
Yeah.
All right. On that note, thank you, justices, for being here, for deliberating so intently, for trying to be so even-handed.
You're welcome.
Appreciate it.
Thank you for deciding my opinion was somehow valuable in this endeavor.
Yes. And thank you, of course, to my co-host, Nikki. I have to say, Nikki does significantly more prep than I do, and I don't think any of this would work without it.
Yeah, clearly.
So, really appreciate that. But
you won this one by the skin of your teeth, buddy.
Yeah.
You got off lucky.
We're not keeping score.
I absolutely
here on the website.
Score.
We will.
Jeez. Seems more official.
Well, because we're gonna have some canon running of like, what
right.
the Sarah court thinks
that I know that our decisions mean something and have impact and like that there's continuity in the plot line of this show. Oh boy, you guys are in for it.
Yeah.
UFOs are real. That's canon.
Relitigated.com if you want to get into the canon behind the Sarah court.
Yeah, we'll link you to the wiki as soon as that is up and running.
Just wanted to make a clarification that is not like Canon, the image company.
Yeah,
no, it's
the
like
thing that
not
pieces
Canon.
of metal.
It's
yeah,
like sort of like the accepted, like this is
truth.
Yeah, this is what we like.
It's how the Catholic
Disney,
Church and Marvel keeps track
MCU
of what's what.
or Lord of the Rings or
Star
Wars.
Yeah. Yes.
All right. Thank you much, everybody. And we'll see you in the next one.
Good jurisprudence, everybody.
Peace out.
Night.
And there you have it, a 2-1 decision in favor of the state of Colorado. This split among our justices is interesting because the actual Supreme Court had the exact same split itself. In the end, both our court and the Supreme Court opted to defer to the states and allow them to set their own rules for when evidence should or should not be allowed. It's important to note that this decision does not reverse the decision in Weeks v. United States, because that case dealt with federal courts, and this case dealt with state courts. This completes the second part of our 3-part series on the development of what's known as the Exclusionary Rule. Tune in next time for the exciting conclusion of the series. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by me. Thanks for listening. Please like and subscribe, and catch us at relitigated.com and also on YouTube at Relitigated Podcast. Until next time, I'm Jarrett, and this has been Relitigated. Take care.